moving on to the TRA.
Yes.
Having been a teacher myself, I understand the importance of protecting your professional reputation as well as your professional work in all capacities, really. As a solicitor, as also a barrister, I can really relate to my clients when they come to me because obviously they're regulated as we are. So Pancho's obviously took a liking.
He's
to
rather
you.
comfortable.
Pancho actually loves snoring, and today he's snoring a little bit more than he even normally does, aren't you, Pancho? So talking about the TRA, well, give me the history, because you, as a solicitor, have even more experience than a lot of solicitors and barristers put together, actually, because you used to deal with the GTC.
I did.
And then the body that followed after. So tell me about that.
Yeah, so I actually still remember that first case that I acted for a teacher. He was the head of a pretty tough academy and necessarily had to make some really difficult decisions, which were not taken kindly to from their perspective by staff members. In the end, he unfortunately ended up in the General Teaching Council, which it was then. I think there were about 123 allegations initially made against him, which we thankfully managed to reduce down to 23, of which 11 he was found, I don't like to use the word guilty of, but, went against him. However, at that time, there was an opportunity, rather than to just be prohibited from teaching, he was given some training and still managed to keep his teaching job. So I was really happy about that. And I remember there being a lot of press around. It was really probably one of my most vivid, but one of the earliest memories I had of a case in the GTC, where literally in Birmingham, everybody was swarming around trying to take photos. And then, of course, General Teaching Council turned into I think it was the National College of Leadership and Teaching. It was the NCTL. And then, National College of Teachers and Leadership. That's what it was. And then now the TRA. So I think the process and the procedures have not necessarily changed. It does feel like it's a little bit of a sort of tribunal onto itself. There's very little governing it other than its own, obviously, procedures. And what I find, which I think is really difficult for teachers and anyone who's hauled up before their regulatory body, is the level of delay that it takes to actually get the case heard. I even actually have a couple at the moment where the client has waited probably at least over a year, and definitely over a year, coming on to a year and a half, just to get a hearing date listed. And it's just awful because these things are hanging over your head. They don't like to get another teaching job until it's been resolved. So, I'm really passionate about that area of law, being part of a regulated profession ourselves. I really empathise with these teachers.
What I really do like about your practice, I have to say, is with your TRA work, you tend to want to get the allegation thrown out at the investigation stage,
yes,
which actually is a big rarity amongst a lot of our profession, because sometimes what happens is that I find clients have been told to fight something, and I understand that, but dealing with it at a ground level or a grassroots level or wherever it can go wrong is so important. So from my experience, I kind of like to deal with things through my clinic in the same way. And I try and sort of nip it in the bud and try not to exasperate, if that makes sense. It's a skill that you have to get rid of it at that stage, which I have to admit, a lot of lawyers do struggle with. How do you do that?
So generally when the teacher does come to me, it's very much at the early stages. So the referral will have been made. And so I'm sort of there right from the outset of the matter. And of course, part of the process is to have the investigative committee look at the case to see whether there is a case to answer. So I do always say to them that from my perspective, I give as much as I can to the first stage, sometimes even more, so that you get the opportunity, because you don't want to get it to the second stage. And what I do, prepare the written representations, but getting as much evidence as I can to substantiate that the teacher on the whole generally hasn't done what they've done, or that there were extenuating circumstances.
Now, that's very interesting, and I'm sorry to interrupt you, but that's a really good point you've just made, because I totally agree with you. However, I don't know if you found this. So I have found somebody's come to me and they've said, here's the allegations, okay, and then they give them a deadline to say, what would you like to say? Anyway, then they'll say, we went to the union, or we went to the lawyer of the union who has said, oh, you don't need to be as detailed at this stage. You don't need to, whereas I'm of the opposite opinion, like you need to be detailed to try and get rid of it.
Yeah.
I had one actually not long ago where it was the head teachers union, and from my recollection, the person that was told by the head teachers union's lawyer were told this, like, don't make it detailed. In fact, the lawyer of the union left it till the night before. After, and I was in the background trying to just sort of tell the person, look, you need to press them. But the bit that I didn't agree with was, I think there needs to be some, for people who are listening out there today as well, some clear understanding of how detailed should that initial response be.
I mean, I often get teachers having tried to obviously go to their union because, again, it's more cost effective from their perspective because they've been paying in and, they try. But often the complaints I get is that the union representative is not available, or they've delayed, or they do often try and get them to, like you say, just put in something basic at this stage and then deal with it if it goes to a hearing. As I say, from my perspective, I always think if you go in hard to the extent with in terms of your defence, whatever that may be, and honestly, I mean, 9 out of 10 cases of mine, they do get, I'm really pleased to say that they do get thrown out at the investigative stage. Of course, some of the complex ones, of course, go forward. Sometimes because the teacher has accepted the allegation. But then again, you're dealing with mitigation. But you've prepared such a good sort of defence, if you like, at the first stage that you can then carry that forward. I mean, I'm a firm believer on trying to get the matter resolved as quickly as you possibly can. I mean, the hearings, as you know yourself, are akin to little trials. And I just find, and you don't get legal aid, you don't get any other financial support. I don't even think legal expenses would cover it. And they are super expensive hearings.
And there's no cost awards at the end.
No, indeed.
And there should be.
There should be, yes.
Should be cost awards.
There are some parties that have acted like, the delays and the amount of money. In fact, actually, the client that I spoke about earlier, I think they ended up having to remortgage their house because it was such... I mean, that was probably one of the biggest sort of TRA cases I did.
But Anita, I understand that completely from a perspective of how expensive these hearings can be. So just let's go by the average hourly rate a lawyer may charge, which could be anything between £250 to £300 an hour, if not more.
Yeah.
Now you imagine from the representation stage, writing the written representations. I mean that document alone to draft, as you know, can take a full week actually. By the time it's gone back and forth and all the rest of it, that's a few thousand just gone.
Yes, it is. So, hence why my focus for them is, the way I also charge clients is to do it in stages of work. So the first would be, let's deal with the investigative stage. And thankfully, if you give it your all and it does work out, then it's been such a relief for them. Obviously, if not, again, you have to manage the costs with each stage. But it's a difficult process. I mean, once you get bitten by the TRA, all you can do is defend your position.
I think your cost model working with your clients is an exception, isn't it, really, if you think about it? Just, I suppose, in a similar way as I work in the reduced fee clinic to keep client costs low, that's all well and good. But do you also find sometimes you get clients, I mean, I'm kind of going a little bit away from TRA cases, but coming back to it, do you find sometimes clients come and feel, because your fees are modest and very reasonable, like that, they should be going for an expensive lawyer who will do a better job?
I mean, I think that there's always a little bit of that, isn't it? That sometimes when you try and be reasonable, somebody thinks, well, what's the catch? Or they think, actually, well, if you're charging that, maybe you're not going to be as good as, I think, thankfully, I'd like to think that the experience, the expertise and the work that you get done for the client from a positive perspective more often than not kind of speaks for itself. And it really is about I mean, it's about doing the best that you can for them, and it is also a job for us. So, I do, but I think the stage of work and the way I try and, financially package, if you like, the cases for them makes it more manageable for them.
Yeah. So just staying on the TRA, which is a very interesting subject, and I think the workload in that area has increased in terms of, well, I say it's increased, but it's kind of like because of the slowness. So there's more teachers being told they've done something wrong. Do you find, well, what I would like to say to my clients, if they have got a union involved, is to go back to that union and tell them that they've had legal advice, but there's a problem, isn't there? The problem there is the union will say, well, if you're going to go with an independent lawyer, we're not going to help you. So that's the other problem.
Yeah.
So I feel very sorry for some of the clients. Just like you, I'm very passionate about TRA work, having been a teacher. How do we address that issue where a client comes to you, they're telling you, my union is telling me this, so what do I do?
Well, I think it's a balance. I mean, obviously, as we know, you can't have two people acting for you at the same time. But what they tend to have done, certainly from my experience, is they've had some initial advice from the union, and then they'll come to me perhaps for a second opinion or to see what I might be able to support them with as a private solicitor. And then I guess it's the choice that they make. And I think they find that the advice that I tend to give them is a lot more detailed. They don't get given the same level of strategic advice that perhaps the union, may or may not be able to give them. So I do think, and there's no disrespect to the unions, but I do think that there's a difference in the level of advice and that they get from a solicitor versus a union representative.
Yeah, and I think the issue with union representatives a lot of the times I found is they're not legally trained.
Yes, exactly.
And they are only used to being brought in at for low-level school issues.
Yes. A lot of settlement agreements or disciplinaries.
And even then,
To be fair, I deal with a lot of settlement agreements where teachers have said, my union didn't advise me to do this or didn't. And I mean, look, I understand why they have to, but I think it's always important, even if it's just as a second opinion, to get a little bit of independent advice to make sure that you're on the right track.
I really do like I really love the fact that you are in agreement about nipping it in the bud, so to say, at the investigation stage. So I suppose I try and advise this to my clients, and this is where I find the difficulty though. So what happens is a referral's made, and from that referral, then the letter comes to the teacher, doesn't it? So we've had a referral made about you. At that stage, there's no bundle, is there? The bundle comes later, doesn't it?
Yeah, you get the notice of referral form, which they've got to either accept or deny. Then once they have done that, then they send you the allegations with the bundle, and then they give you an opportunity to respond to the allegations and any evidence they've got at that point for the investigative stage.
Yeah, I normally always get these when they've kind of gone
further down the line.
Yeah, yours seem to come much earlier.
I think they tend, for whatever reason, the majority of my cases, the minute they've sort of got the TRA, they manage to thankfully find me, and then I do get involved much earlier. It's actually rare that a teacher comes to me and I haven't been involved from the outset.
Referral's made, letter comes from the TRA. There's no bundle there. It's just that you've had an allegation made against you and we'll be writing to you in due course.
Yes.
They don't ask for anything at the back then at that point, do they? So then the bundle comes and then they say...
With the allegations.
What I also advise my clients to do, and tell me if you do this, I tell them to add in any evidence back.
Oh yeah, with the written representations.
With the written representations.
So I think that's what helps in getting them thrown out, because I get character references, I'll get all the evidence that we want. Again, it's almost like the case is prepared from the outset, but heavy front-loaded. It's front-loaded from a heavier perspective. And I think that really helps because I'm getting all of the evidence that they want to seek to rely on early on. I don't think with TRA cases, my view is not to keep your powder dry. You've got to put it all out there in the hope that basically it will get thrown out. And as I say, most times it is.
Yeah, I honestly, I'm really pleased to hear that you do manage to get them thrown out. Your success rate is very good, because that's brilliant. I think, like I said, the difficulty for me is I normally get them a bit in.
Yeah.
But when I give that advice, that challenge it give it the kitchen sink,
Yeah.
I'm met with, yeah, but my union or this or that or the other. It's a difficult one. But I think what I do find interesting is the delay.
Mm.
And I don't know what the cause of this delay is. I don't know. Well, I don't know. What do you think is the cause?
To be honest, just from my experience, so the couple I've got at the moment, there's a couple of cases that I have at the moment. They are, the delay is just being caused by, I believe, gathering of evidence, having to deal with witness statements. Some of them sometimes are, pupils that have moved on or staff members that have moved on. So I think just by sheer volume of, as we know, these cases that can have a number of allegations, I think that's what happens. But to some extent, I kind of feel like it's such an open-ended thing, because other than threatening to JR, which you're not necessarily going to do or advise your client to do, there really is nothing you can do. I mean, the case that I said is almost coming on to a year and a half. I have incessantly chased the solicitors for the TRA, but from their perspective, they just keep saying, yeah, we're still gathering evidence, we still haven't had a date for the hearing. And my poor teacher is just still waiting to know what happens. And even though I say to them, of course, they're not barred, they can still carry on teaching, you all know this as well, that they don't want to do that until they've got this weight off their shoulders. So, I mean, look, it's a really difficult system, and it's not ideal at all.
With the bundles of the TRA, which obviously Pancho loves receiving because you can hear that from him. I have sometimes, with my employment law head, which I'm sure you'll relate to because you also have dealt with employment law issues, that the procedures followed within the schools in gathering statements or whatever it might be are questionable, which then lead to a disciplinary, which then could have led to the referral of the TRA.
Yeah.
So, for example, this is what I'm often advising my clients, is that in the bundle will be a statement from Janice Higginbottom. I love the name Janice. So for example, Janice will never be seen or heard of, but there'll be a statement from her saying, Teacher X did X, Y, and Z, and they did it on this date, and they said this and they said that. But then the other part of it is this, as you'll know. Then you've got statements within the bundle which are taken on behalf of the teacher.
Yeah.
So they're called into a disciplinary, they're called into the office, and then you've got Jeffrey Higginbottom sitting there taking the statement for the teacher, asking them, because Janice Higginbottom has said, blah, 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 blah. So they're saying, right, what happened? And that's paraphrased. So it's not their statement.
No.
It's not their statement.
No.
And because the teacher doesn't know the procedures or the whatever, it ends up in a bundle like this. And then, are you following? Is it quite interesting? So what I find really incredible is that they've allegedly admitted or said things, or they've been phrased in such a way. Then the problem is, as you'll know, if an employment procedure, if a workplace disciplinary procedure is not followed through properly, it makes that process questionable and possibly even invalid.
Yeah.
So, which then becomes a separate matter. But then the problem I find is the teacher's left thinking, actually, I should be actually suing the school as well for a failed procedure, as well as now I've got this problem with the TRA. Does that make sense? Have you found this in your practice?
I mean, not as much with the sort of staff having done that, but I was just sort of thinking as you were speaking. I mean, I certainly have had documents that are questionable for a variety of reasons in the bundle, when then they're just not relevant to the allegations. And I do argue to have those removed. Again, on the odd occasion it has happened, and I've been successful in that. But what I was thinking about whilst you were speaking in relation to that was actually more about what I face when I'm acting for children who've been excluded. So there are some times where the child is giving the statement verbally, and then there's a teacher writing it down. Now, of course, they will then, well, I say, of course, they will sometimes, or do they, read it out to the child, or and then the child has to sign it. But the child often, and the complaints I get are every time that they didn't know what, was being said. They felt coerced. So it just was a sort of similar situation where my brain went to that more than, I haven't had it so much in the TRA in terms of with adults not having written their statements, but I would be flabbergasted if that, if that was evidence, which clearly it is, that they try and rely on.
I suppose, yeah, I mean, maybe I phrased it incorrectly as well, but what I probably was getting at, and I probably should have said it this way, is I didn't so much mean the actual teacher, sorry. I meant they've got other people coming into the office asking them. So they'll get John, Jeff, Janice, whoever else, and say, what happened in this incident? And somebody else what happened in this incident? They'll get them to say it, and then you'll get somebody just writing that. But the problem you got...
So it's hearsay.
It's hearsay.
Yeah.
So you get to the TRA hearing, John, Jeffrey and Janice
They're
are
not there.
nowhere
But
to be
then
seen.
but then it's about for the panel to put as little weight on those
But
on that evidence.
Yeah. However, the issue I find is, unless you are a practitioner who also does employment law, you may not know to challenge that.
Yeah, you may not know that,
And I find, and just like you know employment law and you deal with employment law issues related to all of this, you can also advise your client. So I find my clients sometimes they didn't know that this was an incorrect procedure from an employment perspective. Do you follow?
But I think this again just goes to the heart of you really need to get some advice.
Yes.
And I do always say that to the clients, whether it's a one-off or whatever, just do yourselves a favor because it's so important, and the decision that could go against you is effectively your entire career. So I think it's really, really important to make sure. I always say to my clients, knowledge is power.
Yes.
So, I just think it's important to make sure that all we can keep doing is to tell people to know where they can get support and hope that they find some.
I think it's important in TRA cases, especially for people to find an advisor who has knowledge of employment law as well.
Yeah.
I think that's...
It's not always possible, but I think that there's not many specialists like us around that do TRA work. And I think having that sort of cross knowledge, if you like, really, from your practice, but also because I act for teachers in the disciplinaries as well as, obviously at the TRA, and then having done education law as well. So it gives me quite a holistic outlook on things.
But I think having been a teacher myself,
Absolutely.
I also understand how schools work.
Of course.
And I think one thing I've looked at when I've looked at these bundles is the way in which they're presented as well. I mean,
it's a questionable process, to be honest.
Yeah, I do find the bundles a little bit haphazard. I've looked at some of the bundles, and what I've also found quite interesting is there'll be statements handwritten which have then been typed out and presented as another statement when you have to point out to the panel that actually it's the same statement. It's not another statement. And I think it's not anybody's fault. It's just whoever's put the bundle together the way they... Well, I suppose it is somebody's fault, but it's just...
needs to be identified.
Yeah, I mean, it's an interesting one, but just on the subject of TRA though, whilst we're on it, I find also with the panels you have to sometimes helpfully assist them because obviously they're not lawyers, and I think you've got to make sure that they understand the case. What's your experience?
I mean, as I say, to be honest, I haven't been before a PCC for a while, a professional conduct committee, and if I do, I always instruct counsel. And then of course not to sort of double up the fee for the client, counsel sort of takes the baton over, but yes, I mean, definitely for the ones that I have been to in the past, they definitely require a lot of guidance, which I think they do welcome, to be honest, because ultimately it's about having a fair hearing. And I think, especially if you're legally represented, i.e., the client is legally represented, I think that's the best thing that you can give them, is to make sure that, I always say, win or lose, you've got to walk out of there and think, I gave it my all, and that I was listened to, and I felt like it was given a fair, I was given a fair hearing. So I definitely do think most panels, not always, but most of them will value being guided and being given the advice and being steered just to know what the law is. I don't necessarily always find that a problem. But again, sort of looking back to the exclusion, panels, governors particularly, less so the independent review panel, but governors don't necessarily like it. They don't like to be told what to do. So it can work in both ways.
Yeah, it's a difficult one. I mean, I found myself in front of a panel on behalf of a client who didn't understand what direct access barrister was. So they were asking me questions about... It turned into this discussion about some correspondence, actually, which I think the client had filed by themselves to the panel. and they just couldn't understand why the solicitor didn't do it. And I was trying to explain to them there is no solicitor, and I'm a direct access barrister who can conduct litigation. And I ended up spending like a half an hour. It was such an unnecessary discussion. And then they were all looking at each other like this, and the legal advisor, I think, stepped in ultimately. But coming on to the legal advisor, that's another aspect, isn't it? I mean, I've had a mixture of legal advisors, and I've sometimes had to challenge the cases that they've presented as well. I don't know what your experience is, because some of the cases actually are not as helpful as presented.
Yeah, I mean, I think, again, it probably depends on the level of experience that they have. Sometimes some cases are just more complex than others. And I really think that, as lawyers as well, and you would expect this of a legal advisor, but I think the more experience you have, it's also about the strategy that's employed, as well as the complexity of the facts, and making sure that, procedurally as well. So I think there are so many factors to consider that they have to carry. And I think it's a big job, and you need to make sure that you're doing it justice.